What is premarital property? A simple definition would be any and all property accumulated prior to the date of marriage. Usually in a divorce, premarital property is hands-off and the other spouse has no rights to it. But of course, there are always exceptions. If that property generates an income, then there can be a question of whether or not that income should be used in the calculation of child support and maintenance. And there's always the question of whether or not that property has now converted into marital property. That usually happens with the conversion of that property or the transmutation of that property or the commingling of that property. What does that mean? That means you took that property and you used it within the marriage and you maybe put it into a joint account or you put it under your spouse's name as well, or you used it so much for the benefit of both parties that now it became a marital asset. And that's something that usually the courts would have to decide if there's no agreement by the parties. And if you have a substantial amount of premarital property and you want to protect it, just in case there's ever a breakdown in the marriage in the future, consider a prenuptial agreement or even a postnuptial agreement. And if you don't want to enter either of those agreements, talk to an attorney about how you can protect your premarital property.